Now we're going to talk a little bit about enforcement options. And so if you've been in some of the other classes, I mean, you do your inspection, you know how to do that, and you're figuring out the elements of the violation, right? You're figuring out if you have the evidence to support those. You're coming to this decision. I have decided, I have evidence, I have found this violation. Now you have classified the violation. And it's really important that that's a linear thought, that you don't jump ahead. She said, don't think about enforcement when you're doing the classification, because it's two different decisions. So now you've decided, you have a Class 1 also, or Class 2, and you've decided you're going to take formal enforcement of some sort. So what you're going to do, that's the next presentation, what your enforcement options are. Slideshow. Here we go. Okay. So we're going to talk a little bit about general principles of enforcement. And I used to have, in the funnier presentation of this, I had a picture of the umpire in baseball. I mean, what do you want from the umpire? You want the strike to be the same strike, hopefully through the game, but hopefully the same, strike zone in New York as in L.A., Cincinnati. You want it to be the same. It's the same in enforcement. We need to have swift, consistent, predictable. This needs to be our mantra. Everybody say it with me. Swift, consistent, predictable. Right. And any of you who have trained dogs or children, if we'll use the dog example because that's probably more correct, your dog makes a mistake. What good is it if next week you say, no, bad dog? And I don't mean to be demeaning of the people that we're regulating, but if you go and do an inspection and 3 months later say, oh, there was something wrong, or 6 months later say, we're going to take enforcement action, what are the chances that the same people are even still working there in some, that's why, to the extent you can, you need to let them know then, this is a problem, this is wrong. Or if you're going to take enforcement, have it, become consistent, because an awful lot of our purpose here is deterrence and also just frankly effective communication. Things need to happen. It makes an enforcement action so much harder if it's months or years down the road, because by then so many things have changed that it's just not going to be that helpful. And we want it to be predictable, right? There shouldn't be it shouldn't be a roll of the dice whether or not something's going to happen. It shouldn't be different. I'm so tempted to pick specific examples. Let's say in one part of the state than another. So, and in a lot of cases, obtaining compliance is not enough. 10 years ago when we started the enforcement track at the CUPA conference, an awful lot of the dialogue was why do enforcement? We really don't hear that anymore. Then the question went to how, and now frankly most of the discussions are you all talking to your peers about how you're doing enforcement. I really don't get this, gee, we just want to get compliance. Compliance is really important, and obviously that's the driver, that's what we need to get to. But there are just so many cases where because of economic benefit, because of deterrence, because of fairness, re-inspecting them to death is simply not the answer. So, deterrence. We need to have an atmosphere of voluntary compliance. We can't go out there and inspect everybody and violate everybody. That's a really bad example. Or take enforcement on everyone. People have to voluntarily comply. It's why we put the money in the meter. It's why we all obey the speed limits most of the time. It's why we all turn our taxes in. Because we know if we don't, chances are something's going to happen to us. So we need to have the likelihood that a violation is going to be detected, swift and certain response, and consequences for violations, and the perception and the reality that these three things exist. Enforcement is pro-business. Don't let anybody tell you you have to be pro-enforcement or pro-business. It's the same thing. The regulations that we're enforcing are really complicated and they're really expensive. You've got to have your act together. You've got to be able to read these complicated regs. You have to be able to stay up on it. You need to hire people capable of doing these things. That is all expensive. That is a lot of money. A lot of times I give an example. The first criminal case I ever filed when I was in San Joaquin County was based on a call I got from a plater who said, I just put in $100,000 of pre-treatment equipment. That was $100,000 in 1986. and there's a guy across the street who has a pirate pipe, and he's killing me. I can't keep up with his bids because his costs are so much less. That was the first criminal case. That case was pro-business and pro-enforcement. We put the cheater out of business. And remember, enforcement applies to government. It applies to nonprofits. It applies to educational organizations. Unless they're exempted by the regs, they have the same drivers. Why are they not complying? Because they don't have the money, right? Usually. They don't have the technical experience. So we need to take enforcement action against them. Actually, in some cases, I had some people in those institutions ask me to take enforcement action because they said, I can't get it in my budget unless there's been some negative consequence. That's the only way my department chair is going to give me the money. Assessing penalties, we get a lot of questions about this, and there's some other classes about how to do this. How do you do it? Well, think of, how much does it cost to become aware of regulatory requirements, to stay current? There's capital costs, there's staff costs, delays. This is really important sometimes to find out why a violation has occurred. Some of the classic examples I always think of the stormwater programs, The bulldozers are out there, they got to get going, they don't have time to get the stuff on site, they've got, there's all these deadlines, so oops, we didn't have time to, protect the drains. And if there's a drive to get to the market, they want to be the first one on the market, they're the only business in town that does this work. Those are all economic reasons about why they're taking the shortcuts. The guy who used to do this has, retired last month, and we haven't gotten around to hiring somebody new. Those are significant cost savings. You need to, figure a way to factor those in when you're setting penalties. Economic benefit, a lot of people get hung up on, well, they didn't make money. Economic benefit is not an evaluation of net profit, okay? They still saved money even if they didn't make a profit. They saved money. They didn't spend money they were supposed to. An awful lot of the reasons why some businesses are cutting corners, they have a failed business model. They can't stay in business if they had to spend all the money they should. Unfair competition, this is the level playing field. The folks who aren't there, your job is not to keep them in business. Your job is to make them comply with the law. And even if they are the only business that provides a certain service, in the AEO case studies, there's an example of a case, the only ice producer, and it was really important. It's in Humboldt County, but their ammonia system was a disaster waiting to happen. Through the compliance efforts, they did end up, they made the decision to go out of business because they couldn't afford to stay in business. But guess what? A new ice company came to town, new equipment, it's really good, it's much safer, and that's the way it's supposed to happen. If you're keeping the bad business in business, you're preventing another competitor from being able to succeed. So, and I really like this because I don't do the math thing. There's a PhD economist who actually wrote his thesis about economic theories of deterrence. And if you really want to impress somebody in a settlement conference, show them that bottom number. But it's just a logical process. Take a business that's operating at least 40 hours a week, probably at least 50 weeks a year, if not, 365, 24/7. How often are you out there? And even the best inspector on their best day, what are the odds that you found every violation at the facility the one day of the 3 years that you were there? What's the probability of enforcement action being taken? When's that going to happen? When's the fine going to come? There's a discount rate. Okay, that's what you're running through all these numbers. That's why if they saved $50, you can't have a fine of $50. Otherwise, they've come out ahead. They have made a good choice to violate the law and will probably continue to do so. Environmental justice, we have it codified. We're supposed to have fair treatment, okay, of folks in different kinds of situations. We need to take this into consideration when we take enforcement actions. This is the enforcement pyramid. The most common kinds of enforcement that are taken are the informal. Then we go to administrative, civil, and criminal. We're going to go through all of these individually. Informal enforcement, verbal warnings, anything where there's no significant enforceable penalty. That's informal enforcement. A notice of violation with no penalty. A notice to correct. It has different acronyms and different programs. It's really important that you document all violations that you see Even if they corrected it, you have to write them all down. And if you have done compliance assistance, if you have given them a warning, write it down. We have to have a record. Think of how this plays into what you've just gone through in the classification. If you didn't write it down, how do you know next year or the next inspector that you have a repeat violator? And that's not going to be a minor violation. Now you're going to class 2. You have to document all this. Even if you think it's not important, it was a minor, you have to write it down. Because it's the aggregation of violations, it's repeated patterns. You have to document it. It's really important when we get into classification and then enforcement options. Administrative actions, I think you all know what those are. Administrative enforcement orders, we have lots of classes on those. Other programs would have other names for them. But if you take a permit action, if you take a license action, that's an enforcement action. The standard of proof you will have to meet if you go to hearing is a preponderance of the evidence, and that's where it's slightly more likely than not that the violation occurred. That's the government's burden of proof in these kind of actions. Here's an example from San Diego and our AEO case studies class. That's tomorrow morning, this room. And I'm sure, how many of you have been involved in an AEO? Or at least your office has been, you know. Okay, because everybody should have taken one of these by now. I think we pretty much, every CUPA has, and PAs, we're looking at you next, so, you know, get on board. I'm sure that you've had some Class 1 violations in your program. And if you have a Class 1, you should be taking an enforcement, a formal enforcement action. This is, you know, for a formal enforcement action, you're talking an administrative, civil, or criminal action. One of those three. If you have a Class 1, writing that letter and telling them to fix it is not sufficient. You have to take a formal enforcement action. So the least you can do is do an AEO. And you should all be able to do that now. If you're having any problems with that, I have my business cards in the back, and the folks from our CUPA program would be willing to help you. A lot of times we have CUPAs in your area kind of mentor you to walk you through how to do that. But pretty much I think we've got everybody on board that they're able to take these actions. So there's an example of an administrative enforcement order from San Diego. Civil actions, that's where you're referring it usually to some attorney outside your program, either to a district attorney. Sometimes county councils will do these, sometimes in the larger cities. The actions go to court, there are monetary penalties, there's injunctions. There is a civil case studies class this afternoon in here, 3 to 5. Standard of proof is the same as an administrative action. It's a preponderance of evidence. Here's an example. San Diego sends out really great press releases, which they're not my favorite. Well, kind of they are. And they do a lot of AEOs, they do a lot of civil actions, they do criminal actions. They're able to take advantage of all of the options. So here's an example. So you've got a release that was hosed down, it goes into the storm drain. Yeah, this is a Class 1. Failure to report, there's a fine. They also got some compliance schools, made them get a new management plan. There was a recovery investigative cost. The district attorney brought this action. If you notice, there was also a fine brought under the Business and Professions Code 17200. That's the Unfair Business Practices Act. That's used a lot in conjunction with the Health and Safety Code when civil cases are brought. Again, firing home the message that these are any violation of the law is an unfair business practice, not only in theory but in the law in California. And for more about civil cases, here you go. There's also examples. If you actually want to see the larger multi-county and statewide cases, we've been posting those on the CalEP website, both the complaint and the final orders. Criminal actions. You can also get fines and imprisonment. Infractions, we don't really have a lot of infractions in the programs. Those are like traffic tickets where you just pay some money. Misdemeanors where the maximum jail time is 1 year. A felony, if the possible maximum imprisonment is state prison, which is for more than 1 year, it's a felony. And we have a lot of felonies. We don't have them in all the programs, although a lot of times they'll actually be crimes that you will see that might not be the Health and Safety Code, might not be a felony, but there's a felony somewhere else. And we have some handouts on common environmental crimes in California. Those will be at the back of the room. If they're not there now, they're in the box. And I know we also have a training booth out in the exhibit hall that has some of these. Criminal cases are filed through the court system. In the larger cities, Los Angeles, Long Beach, San Diego, the city attorney can file misdemeanors, and sometimes environmental cases will go there. Usually they go to the district attorney in each county where they can file any kind of case. Occasionally also we work with the Attorney General. They take cases sometimes, and the U.S. Attorney's Office obviously files the federal cases. Standard of proof here is different. It's beyond reasonable doubt. And we don't have a specific class on criminal environmental cases this year, but we probably will next year at the class. If you're looking for training on that, there's actually an Introduction to Environmental Criminal Enforcement class that's given every fall by the Western States Project. There are scholarships available to that. If you go to Cal EPA's Enforcement Training webpage, you'll get information on those. Criminal remedies, probation, fines, incarceration. A lot of times we won't get jail time on somebody in the first time, but we get probation, which is very, very helpful with that chronic violator, because they're now under the judge's order to fix things, to do things. The number one condition of probation, obey all laws. That can be really helpful. And again, if it's a company that may or may not be able to obey the law, getting them on probation, there have been a number of instances where, because they kept getting found in violation of that probation condition, they make the decision to close down. We're simply not able to do it. And there's just a lot larger hammer when it's the judge telling them to do that, as opposed to the regulator saying, you know, you need to obey the law here. Because if they don't obey the law, if they didn't get jail the first time, violate your probation enough, you will end up in jail. And that's a significant motivator for most rational folks. And here's an example. And it's another San Diego example, again, because I had the press release and could cut and paste it into the PowerPoint. Here's a facility that didn't have a permit at all. Class 1 violation, total denial of that program element. They were sentenced to 3 years probation. Here are their probation conditions: obey all laws. They had to do 20 days of essentially community service, pay the fine, get your business tax certificate. They not only had ignored the CUPA's requirements, they kind of were doing that, you know, I'm not going to have any paperwork or permit. So they had to get their business tax. They had to get their permit. They had to allow CUPA to inspect the premises. Another common probation condition is a search waiver, that you allow the government to come in and search your facility at any time, day or night, with or without probable cause, with or without consent. When you're on probation, you have to waive that and let people go in and consent. So for problematic facilities, misdemeanor cases and misdemeanor probation can be very, very helpful. And you should be talking to your local prosecutor about that. You need to make sure you're talking to the right person in the DA's office, particularly if it's a large office. If you just go talk to the filing deputy or one of the generic folks, they're not going to have the faintest idea what you're talking about, probably not going to get your case filed. In almost every county DA's office, there is someone who does environmental crimes, environmental cases, also environmental civil cases. If you don't know who that is, you can contact me at Cal EPA or contact Bill Jones, who's your multi-state coordinator in LA County. We can help direct you to the right person. Because like you, that person will change over time. A lot of the rest of them are retiring these days or getting made judges, so if you don't know who the current deputy is in your office, let us know and we can direct you to the right person. If you're in a rural county where you might be using the services of a circuit prosecutor, you can contact the DA's Association, CDAA, in Sacramento, and find out who the circuit prosecutor for your county is. Any questions up to now? Also, the third day of the conference, everybody starts to drag. Okay, and this is the long day. This is when we have to go to 4 classes. All right, choosing an enforcement action. It's kind of like violation classification. It's a bit of an art more than a science. And this is all going to sound very familiar. What's the degree of deviation? What's the potential for harm? What's their history? Have they tried, or have they totally blown you off? What's the deterrent effect, not only on this violator, but on the regulated community? You've got some unusual facts, and then, of course, what are your resources? What option are you going to choose? The reason this is plural, there are cases where, we take administrative, civil, and criminal action. It's not a one or the other. Sometimes cases need more than one. You might need to be revoking a license. There's an individual who's going to get a criminal case, but we have some long-term or multi-program issues, so there's going to be a civil case also. So it's not necessarily one or the other. Civil cases, the injunction relief can be very helpful if there's going to be long-term cleanup issues. If you have more than one violation, let's say they have a CUPA violation, they have an air violation, and they have some other program, why should you all be taking individual administrative actions that might be a lot more efficient, and you get the coordinated, to make sure that everybody's on board. If they can't be in the building, they have a planning violation, then why should you work with them on getting permits if they can't be there? That's why that kind of inter-program coordination can be really important. A lot of times that makes a good case to send to the DA. But it does mean that the prosecutor has to agree to take your case. So at least you have to go through the process. Decide the enforcement option, refer the case. Again, the prosecutor may not be able to take every case you ever send them, but that doesn't mean that you need to stop sending them the cases. You need to let them make that decision. The district attorney in each county is elected by the people to make that decision. And I'm jumping ahead because that's the next couple of slides. All right, civil or criminal? Someone once explained that a criminal case is when you read the report and you want to throw your coffee against the wall. That there's just that little element of, this is really wrong. Or there's not a chance we're going to get voluntary compliance. If these people have totally ignored you, lying, cheating, stealing, that's a criminal case. You need to be talking to the DA. So who decides? Who can tell me who decides what's a crime? Come on. Thank you. If you really want to drive a prosecutor nuts, you say, as a regulator, we decided it's not a crime. And that will make them very angry for really good reasons. Again, the district attorney was elected to make these decisions. You need to give them that information. And it's the same way when I talked about, the filing deputy. They're going to sit there all day. They get a stack of reports from the police. They don't file every case the police gives them. They make a decision. Is the evidence here? Is the jury appeal here? Can we handle all these? And right now, DAs are going through the same thing you are. They don't have enough money. They can't file all the cases they want to. But what's going to get done, excuse me, is their decision, not yours. You need to give them the information. You're the witness, okay? You're the witness. You prepare the information, give it to them, they make the decision. Yes? Could you hand me the water?
If you get a bunch of cases and they don't go forward, but you still have this business,
Right.
that's not nice.
The question was, so I've referred some cases, but the DA can't handle it. What do you do? Then you have to go back and do what you do. You issue the AEO. If that's the least. You could also, again, you can contact Bill Jones as the CUPA issue coordinator or myself, and we can take a look at perhaps sometimes when the DA declines a case, the Attorney General might be able to pick it up. Or if there are federal violations, we can talk to EPA either through their criminal investigators. They also have some attorneys that coordinate actions, so there might be a possibility that we get another prosecutor because there is that overlapping jurisdiction in a lot of cases. But if it turns out that really no prosecutor is able to take the case, then don't do nothing because, again, this was a case that you thought should get more than an AEO. So at least do what you're going to do and file that action. Because, again, maybe if they then violate your AEO, you take it back to the prosecutor, and now it might be more significant and they might be able to take another look at it. Questions up to here? Yes?
Is there a time frame or a window of time that you can or can't do that?
Do I have that? The question was about, is there a time frame? Absolutely. For a misdemeanor case, it's a 1-year statute of limitations. There's some exceptions, but generally speaking, it's a year from the date the violation occurred to the date the DA has to file, which again is why you need to have that communication on the timely basis. If you refer a case to them 13 months after it happened, there's nothing they can do. They can't file it. Federal cases, there's a longer statute, but again, not all of your cases are federal, and the feds are pretty limited on the cases they can file. But if there's a possibility of a criminal action, go and talk to the prosecutor soon. Talk to them before, don't wait until you have your 3 binders to walk in. And again, that's part of the purpose of task force meetings. 2 slides ahead. Have those discussions. This is what I'm looking at. Are you interested? Because if they're at all interested in the case, you're going to need to get on it to get them that information. Civil cases, there's a longer statute. Generally speaking, it's 5 years. So, and we're going to cover that a little more. What your DA can do for you, they can file cases, and obviously, If you take an administrative action, you're limited to what your laws and regulations are. In a significant case, I will guarantee you that facility is violating laws in addition to the CUPA program. Penal code, other local code violations, like talk to your code enforcement people, they're going to have code violations too. Pre-filing meetings, the DA can assist you with warrants, and again, depending, every prosecutor is a little different. They might be willing to have office meetings. A lot of times a meeting at the DA's office kind of gets people's attention, and you might get to compliance, without having to file. But again, that's the DA's decision about what they're going to do. There's your local DA that talks about where you can find them. There's the information on some of the various contacts. The advantage of criminal prosecution is deterrence. There is no deterrence like a criminal case. If there's been a criminal case in your county, everybody in that community is going to know about it. Your regulated folks are going to know about it, and you're going to see an uptick in compliance. I guarantee it. It lasts for about 5 years. Indications of crime. How many of you how many people conduct inspections? Right. Put your hands in the air. Yeah. How many of you ever been lied to? Who's never been lied to? Okay. Yeah. Well, what do you think of with crimes and criminals? Lying, cheating, stealing. Okay, folks. And again, go back to your violation classification. I don't think that's clearly in there. I think it does. It has to do with the interfering with the, performance of the program. Yeah, that means you're being lied to. And actually, in federal law, if they lie to you, there's this thing called the Sarbanes-Oxley Act. It makes it a federal felony to be lying to the folks about the program. So where can you find out? Where are you going to get help? What about training? Task forces. And we really hope, I know task forces have kind of fallen on hard times. If you don't have a task force in your county, please call me. We'll try to get one going. And again, the prosecutors are so tapped for time that if they can't do the meeting, you do it. A CUPA can chair the meeting. You invite the prosecutor, and they'll be able to come when they can. Get together with the other regulators in your county, in your city, and find out what's going on. If you think about all the information, how many folks go and regulate or inspect that gas station? For heaven's sakes, why aren't you talking to each other? Because what you see as a minor violation, you find out they're in violation with everybody else. Maybe that's not going to be, something that's going to be solved with an AEO. Unfortunately, we're not able to share data. I mean, we're 2 years away from getting our CUPA data together. Yeah, wouldn't it be nice if we could click on a button and find out they've got air violations, they got weights and measures, code enforcement's been after them. We really need to work on that. So for now, we have the task force approach where the folks in a county or in the larger cities get together. I highly recommend that you meet once a month, once a quarter. How much changes in 3 months? Make it a 30-minute meeting. Make it a 1-hour meeting. I'm kind of the believer that no meeting should ever last more than an hour. Think about letting people call in so that you can get that information going. Here's some of the advantages. It enhances the detections of the serious crimes, exchanging information, prevents redundancies and conflicts. Again, you don't want to be working on permitting a facility when the air folks say that paint booth can't be there, or the code enforcement say that paint booth can't be there. Here's some of the agencies that usually participate: prosecutors, Cal EPA, but then some of the other people: Fish and Game, Code Enforcement, Environmental Health, say if they're not the CUPA, other local agencies. There's our website where there's a list of task force, and there's a contact person as the DTSC contact person. If you need to find out, you can contact them and they'll let you know, okay, the meeting's the first Tuesday of the month at 10 o'clock in this usual location. Enforcement is a public process. All final documents are public records, and a lot of times too, your inspections and investigations, once the action is over, is going to become public. You never want to do something that is going to be a poor reflection on you or your agency. Never agree to secret or off-the-record settlements, because you know what? Someday they're going to be public, and you're going to look bad. And if the purpose of enforcement is deterrence, it's like the tree falling, in the forest that nobody hears. The enforcement action that gets shoved in a drawer that nobody hears about doesn't do much good. I also encourage you all, and frankly, it's on my to-do list to require this, do a press release for every single enforcement action. Just do it. We need to communicate what we do. Post them on your websites. Okay? We need to let people know what we're doing. And again, it's that deterrence value. If someone, say you've issued an AEO for failure to file a business plan, and they're going, well, why should I pay this? Click on the website. Oh, here's the 10 AEOs from last year where they paid the same amount of money they want to get from me. I guess I'll pay the money. It also means you're being fair. You're treating people the same. Questions? You're all very quiet. Yes, sir.
This seems to conflict with what our DTSC evaluators told me. He said clearly and repeatedly that we get to another CUPA that we need to fine for every violation, no matter how minor.
The question was, this seems to conflict with some other advice they've gotten. Did you talk directly to the DTSC evaluator? Okay. Well, maybe we can talk afterwards, because I don't think that's correct, and I'm not sure where the hitch in the information is. Question?
I asked about the time period, and so let's say you set the case to the VA for whatever reasons, they decide either not to take it or whatever reason, comes back to you at a very lengthy period of time, and you decide to do an AEO. So is there a time limit for an
Yeah.
AEO?
The question is about the statute of limitations on an AEO action. Actually, statute of limitations implies there's a law somewhere. And while we have their clear statute of limitations in the penal code for criminal cases, in the health and safety code, and other places for our programs, there are almost no statute of limitations on the book for administrative actions. What we suggest is that you follow whatever the civil standard is, which for most of our programs is 5 years. We did just change the law in CalARP from business plans. They didn't used to have a specific statute. Now they're on the same one with hazardous waste and USTs, so it's 5 years. I think APS is the only one where we don't have a... I'd have to go back and look. And it is in some of our other training materials. So, generally speaking, take a look at what's the civil statute and use that. But there's no clear statute. But it'll be longer than the criminal statutes, which are 1 year for misdemeanors and only 3 years for felonies, which I didn't appreciate are really short. Other states have much longer criminal statutes. California has really short statute of limitations in criminal cases. Questions? More coffee. All right, I think we're done. Thank you very much. Enjoy the rest of the conference.